As per now, we have discussed about the volonté non fit injurier. So now let us understand the other defenses under the law of tort. The inevitable accident, which means an occurrence not avoidable by taking any precautions by a person. Case Stanley versus Powell of year 1891. In this case, the plaintiff and the defendant had went for the peasant suiting. While doing so, the plaintiff got injured by the bullet fired by the defendant in the course of that particular act of peasant suiting. The court held that while there was no intention of the defendant to harm the plaintiff, but it was an inevitable accident, hence the defendant was not held liable. Si vis major, which means a superior force. Or in simple terms, we can say an act of God. Case Nichols versus Marsland of year 1876. In this case, the defendant created an artificial lake on his land for collecting water from natural streams. On fine day, it was found that an extraordinary rainfall, the heaviest in human memory. Due to this, the embankments of the lake got destroyed and washed away the bridges belonging to the plaintiff. For that, plaintiff sued the defendant. The court held that it was not a normal rainfall which has caused that much of destruction. So the defendant was not held liable as it was considered as an act of God.
D. Necessity, which means an act which is committed to prevent the greater harm. There is a sentence related to the term necessity that says necessity knows no law. Case, Lee versus Gladstone. In this case, the plaintiff was on hunger strike and the defendant forcefully fed him to prevent his life. Because it was done to protect someone's life. The court did not hold the defendant liable as his act was to prevent the greater harm. There is one more landmark case related to it is Cope versus Sarp, which is related to fire. E. Statutory authority, which means as act authorized by in statute, for example, municipality, state and police forces. Case, Vaughan versus Taff Vale Railcom. In this case, the crop which was planted beside the railway track got burnt due to the spark generated from the locomotive engine which was moving on the railway line. The plaintiff sued the defendant for the harm he has suffered. The court held that, because it was in statutory authority, and the spark was not generated by any individual. Hence, the plaintiff will not get any damages. F. Private defense, which means when a defendant tries to protect his body or property or any other person's property, harms another person by using reasonable force, under an imminent danger and where there is no time to report the authority. G. Mistake, which means a misunderstanding happened while doing or committing any act. Mistake is of two types, asterisk mistake of facts, which means a person is mistaken by fact, but not by law. Mistake of fact can be an excuse under the law of tort for escaping from the liability, but it is not an excuse under the criminal laws. Asterisk mistake of laws, which an individual is not aware of the laws. But mistake of law is not an excuse in both civil as well as criminal cases.